to Secrets of the Credit Industry. My name is Mark Mays. What I'd like to do is go over the booklet that you'll receive with your material, Secrets of the Credit Industry. And what we have here on page 2 is an overview of the Fair Credit Billing Act. And then on page 4 is a letter to a credit card company if you're disputing charges that you've had. Most people don't know that they can dispute a charge on their credit card billing up to 4 years. And then on page 6, 7, and 8, you're going to see sample letters where you can dispute information that is on your credit report. And then on page 12, 13, and 14, you're also going to see letters, sample letters to TransUnion, Experian, and Equifax, also disputing various forms of outdated material that may be on your credit report. And on page 15, we have a sample lawsuit against a credit reporting bureau that you can look over and get an idea of how you would lay out a sample lawsuit in case your credit report has been damaged and hasn't been repaired. Now on page 18, there's that continues that lawsuit, and that will continue on through page 23. And then on page 24, there's some sample lawsuits against some third-party companies and debt collection companies that you can get an idea of how to lay out a sample lawsuit. And then on page 33, you'll see the Debt Collection Practices Act. That is known as the Fair Debt Collection Practices Act. And this is where a lot of consumers look at their rights regarding debt collectors trying to collect debt from them. Most people think that they just have that initial 30 days, and it really depends on when you have first knowledge of that letter. I've seen letters where third-party debt collectors will make accusations that they've been repeatedly trying to contact you. This could be the first letter that you've ever seen. You still can dispute that, and you want to dispute whatever allegations they're trying to say. If this is the first notice, you want to say this is the first notice that you haven't been contacted by them. This is the first letter you've received. There are third-party debt collectors, and it seems like we're seeing this a lot, especially with the shrinking of the economy that we've been experiencing over the past 3 to 4 years, where lawsuits are becoming prevalent. And what's important to remember with that is that with any lawsuit, there has to be a competent fact witness. And a competent fact witness, a lot of people don't know what that really means. But a competent fact witness is one that has first-hand knowledge of the facts. And we're seeing a lot of lawsuits that are being brought forward, and the pleadings are brought into court and they never provide any evidence, never supported by a competent fact witness. And this is what's exciting. Even though a lot of people have lost property, lost money, if the party bringing the suit never provided a competent fact witness, evidence supported by a first-hand knowledge, then it can be what's called a void judgment. The court should have never made a ruling on that. Evidence must be supported by a competent fact witness that has first-hand knowledge of the events. And in almost the majority of the cases, you'll see the initial pleadings of the lawsuit that's been brought against you or somebody that you know, and there won't be an affidavit, there won't be any evidence supported by a competent fact witness. Now, what's really incredible about this is that if there isn't a competent fact witness who's presented evidence, usually in the form of an affidavit, then the court doesn't have what's called subject matter jurisdiction, and in all effect cannot make a determination on it at all. In other words, the party who brought, typically the attorney who's filed the pleadings, the court doesn't have the authority to make a decision on the case one way or the other. It must be dismissed because they don't have the supporting evidence to prove their claim. If the case is not supported by a competent fact witness, the case can be voided. And you may be hearing a lot about what's called a motion to vacate a void judgment. What's great about a judgment that would be void is that on its face, if the court lacked the authority to make a ruling, then that can be voided at any time. So it can be several years later, after the fact. You may have lost property. And if the other side that sued you did not bring forth evidence supported by a competent fact witness, then the court may have lacked what's called subject matter jurisdiction and may not have been correct in making that determination against you. And since it would be void, it would be a fraud committed by the plaintiff who didn't bring forth a competent fact witness or evidence supported by that witness, then that case can be voided, and you may be able to get your property returned to you, or the value, the fair market value of that property could be returned to you. And on page 56 of your booklet, you'll see an outline and a discussion of what a void judgment is, and you may see that you might benefit from that in your own case. On page 55, there's another interesting fact. When we see the pleadings that go into the court and the case is not supported by a competent fact witness, in many instances you'll see where the attorney will show up and will actually testify. And that's very important because on page 55 you'll see that attorneys cannot testify unless they are a competent fact witness with first-hand knowledge of the events. And in almost every instant they're not. And more importantly, most states will have laws that say the attorney cannot testify and represent the plaintiff at the same time. An important thing is if you do find yourself involved in a court hearing and you catch the attorney testifying saying that Mr. So-and-so did this or Miss So-and-so did that, then you want to do what's the most powerful thing you can do is object. You want to speak up and defend yourself and say, I object. The attorney is not a competent fact witness and cannot testify for a witness who is not present. On page 60, you'll see some Oklahoma statutes regarding falsifying evidence. If a third-party debt collector, through an attorney, submits paperwork that's not true, then it could be considered false evidence, especially if the attorney bought the debt. And what most people don't realize is that in many cases, the attorneys have actually bought the debt or they have partnered with this third-party debt collector to bring a suit against you. And if the attorney purchased the debt, in most states, it's a misdemeanor for them to purchase the debt with the intent to bring a lawsuit against you. And on page 62, you'll see the Oklahoma statute regarding that, where attorneys buying demands for suit are misleading inferior courts. And you will have to look up the law in your own state, but in most states it is a criminal act, either mainly a misdemeanor, for an attorney to purchase debt and then turn around and sue you for it. And on page 63, you'll see a sample of a void judgment, and you'll see how that's laid out. And if you feel like you've been wronged by the court system or by a party that sued you, you may want to consider looking over that. And that's pretty much the overview of the booklet, Secrets of the Credit Industry. And for your convenience, we have created this information in a CD format that you can use to cut and paste from and use in your own work.